This is the wrong, it's attached, so that's the key.
Is there a difference in insurance?
So we'll start this one.
Well, the only thing that's on
I
it
think
is
we
that,
should be-
because it's now
Yes,
part of the
there's
house,
people in there.
it's a detached structure. So while I would automatically have coverage for a detached structure, now I just increase the value of my home because it's an attached.
Is there a way you can expand it to
Yeah.
that, get rid of that stuff in that right hand corner?
So you just can't win sometimes.
Presumably, we need.
Perfect.
So I wish it was that simple. Or it never really should have.
Are you ready to do the question? Okay.
Yes. Yes. So there's 10.
We're going to get started here in just a few minutes. Before we get started, there's been a lot of concern about how this process works for preliminary site plan approval. So our attorney is here, Chuck. And before we get started, I was wondering if you could, share with people on Zoom and that are here tonight how this process works, why we have a zoning ordinance, how the procedure goes, and what we're legally bound to do and not do.
I'll be glad to.
Okay?
We're gonna do it before we start?
Yeah, let's go ahead and just,
Well, whenever we talk about development of property in townships, we have to think of three separate bundles of rights. You have a property owner's rights to develop and use their property. You have a municipality's right to enforce reasonable regulations on the development of property. And you got neighboring properties' rights to be able to use their property without unreasonable burdens placed on their property. All three of those bundles of rights are independent of one another. Townships have their right through law, what the state allows them to do, and that's through the zoning ordinances, and it's through the Planning Act. Private property owners get their rights through common law. Townships cannot enforce a property right owner's rights to use their property. Private property owners can't enforce township zoning or township planning rights that they have. So they're all independent and they're all competing against one another. The only rights that the township has are the rights that the state gives it. We have absolutely no independent right to regulate property other than what the state allows us to do. The state allows us to do that through a couple of acts. One is the Zoning Enabling Act, which allows the township to create zoning districts and to create regulations within those zoning districts for the development and the use of the property. We also have a Planning Act, which allows municipalities to create planning commissions. Planning commissions have a right to take a look at individual projects that are proposed to see how they fit within the scheme of the zoning ordinance and within this thing called the master plan to make sure that it complies with not only what rights that the township is given by the state, but the state or the township's own zoning ordinance that they've adopted. Now, it's important to understand that townships have to be reasonable in anything that they regulate. All the regulations have to be reasonable. If they are found to be unreasonable, then there are potential pretty drastic consequences. If a township is zoning property in an unreasonable way, it can be considered a taking by the township, and the property owner can sue the township seeking a couple of different things. One of the things that they can seek is an order of a court to allow them to develop the property the way they want to. And also, they can seek damages. And frankly, they can get both. Because if a municipality stalls in approving something that ought to be approved, the landowner can be entitled to damages for a window of time in which they are denied to develop their rights, and also be entitled to develop that property according to a court order. Now, it's interesting when courts are asked to do just that. The township or the courts are not word for word bound by the township zoning ordinance. You will find that courts, if they are asked to approve of a plan that because the township has unreasonably denied it, they will never, ever make the restrictions on the development that they're approving more restrictive than what the township does. But on many occasions, they will make it less restrictive, which means the township has lost certain rights that they otherwise would have had to control that property. I can think of a major development 25 or 30 years ago south of here. One of the townships zoned property around a lake which was previously a gravel pit. And they zoned the property residential, but they made it a 10-acre minimum lot size. And the developer tried for many, many months to get the township to reconsider the minimum lot size. They sought variances and things like that, and the township wouldn't budge. And so a lawsuit was filed. The court found that the 10-acre minimum was unreasonable. The court then dictated what would be a reasonable lot size and authorized the development. And what that meant was, by doing it that way, the township lost all control over that development. The court decided that development. In addition to that, the developer was awarded damages because there was a lengthy period of time over which they were prohibited from developing that property. So it was a double whammy. And the lesson, I guess, for every municipality is that everything that you do has to be reasonable. And there are many examples that would be unreasonable. For example, if you had residential property just like that down there, if it's residential in an area that a reasonable person would say you need more dense development, it's unreasonable. Townships have the ability, for example, in another example, to regulate the height of buildings on property. It would be really unreasonable for a township in a residential zoning district to say you can't have a structure more than 5 feet high, which means everybody would have to build underground. It would be unreasonable. So everything the township has to do has to be reasonable, and it has to be within the scope of the powers that the township was granted by the state. So Tyrone Township has its own zoning ordinance, and in that zoning ordinance, we have all kinds of zoning classifications. Many of those are residential zoning classifications of various types. And each of those districts have their own sets of regulations, and they also have some that are common. Whenever a property owner comes to the township seeking to develop property within that residential district, they have to comply with the zoning regulations that we have. If those zoning regulations are reasonable, the township has to follow its own zoning ordinance, and it has to review the proposed development in accordance with its zoning ordinance. It cannot deny a development simply because. So if you have a lot of opposition to the development, that doesn't matter. It has to be something based on a reasonable regulation that the township has adopted according to state law. So when the township receives an application from somebody or proposed development, we have a couple of different steps that the township has to go through in looking at the development. And in our township, we have a planning commission. And the planning commission can review a proposed development. They review that development against the zoning ordinance. They take a look at that development after consulting with experts to determine all of the effects of that development in that area and whether or not criteria that the township is able to control is being followed, but not overly burdensome. So for example, you have property and you have potential stormwater drainage issues. The township has a right to look at that, and they have a right to determine whether or not the proposed development is properly handling its own stormwater. You can also take a look at traffic. You gotta make sure that there's a good traffic flow in the development so that it doesn't harm neighboring drivers in other areas. So our planning commission takes a look at all the information that it is given. They compare that with our experts, and then they make a recommendation as to whether or not this development satisfies the township's zoning ordinances and their planning criteria, and they make a recommendation. So whenever we have a proposed development, it's a development that is thoroughly reviewed by the township before a decision is made. And it's based on whether or not it complies with our zoning. The zoning has to be reasonable. And the criteria that the Township Planning Commission and the Township Board uses all have to be reasonable, and it has to be based on whatever expert opinions have been made as to whether the development is in fact reasonable. So if we don't follow the rules that we are given, we potentially face major litigation. And that litigation could mean we lose control, the ability to control the development, and also we could be hit with a large damage award. Approval of a development has to be based simply on reasonable ordinances with reasonable input by experts. If we make decisions based on anything else, then we are setting ourselves up for some potential problems.
Thank you.
You're welcome.
Can I ask a question?
What's the basis of your question? For clarification, or?
Yeah, I just want to ask him a question. He's talking about law.
Uh-huh.
I'm Scott Dietrich, by the way. We hire a lawyer to support us at our township. We hire a planner to help develop our master plan. And then when they come in and someone wants to do something, when it pertains to zoning, and they find a loophole, or they say the language is vague, I mean, it's just tiring for us residents. If we do make a master plan, we hire legal, people, pay people that are supposed to be qualified to protect us, and we got another lawyer out there looking for loopholes. I mean, it's like we're in a no-win situation. So, believe me, I've been coming to these meetings for years.
Mm-hmm.
And you're our lawyer, we have a planner, and I've been to a lot of meetings, I know what we want to do in this township. It's spelled out. I mean, the intent is there, what we want to do. It seems like we're looking for loopholes. And I've seen the planning commission, everybody's too fast to rubber stamp everything. Now, you come in here and tell us, well, our hands are tied because we're scared to death we're going to get sued. And I don't like that. To me, it sounds like blackmail. I think you're brought in here for one purpose only, because there's development coming in here, and you pretty much spelled it out. And that's the way I'm feeling. And I'm sorry, but I've been in meetings where we try to say we want lot sizes a certain size. We don't want density. This is what I don't think it's too hard to ask that we stay rural. Want certain things in here. I'm hoping you as our attorney and our new planner, I don't know what we can do about our last one, if they left the language open, but I want to be protected. I've lived here most of my life. Not in town, I'm Deerfield, right down the road, just over the border, a couple miles away. But I want to most people want to live here with their kids, but you guys are killing us with loopholes.
Mm-hmm.
So, do we blame the planner and the last lawyer for not protecting us on certain issues? And can you protect us on certain issues? Because it seems like loophole after loophole, we just keep getting killed.
Well, I've defended the township on many occasions in court, and for the most part, we've been successful.
Okay.
And I will tell you, there's crafty lawyers out there that make a living off of looking for loopholes.
Yeah.
And it's not as if those loopholes are there and we see them. It's that they are able to convince a judge that it's a loophole, and that's what happens. I would tell you that all of the communities out here in the western suburbs of metropolitan Detroit at one time were just as rural as Tyrone Township is. In fact, our office represents Iosco Township too, which is even more rural than Tyrone Township. But the simple fact is that as people move farther and farther west, or from Flint farther and farther south, or from Ann Arbor farther and farther north, they buy big chunks of property. Sometimes it's farmers that are tired of farming, and they're looking to develop, to make money. The township is forced to comply with the state law. We have no rights to make regulations other than what the state tells us we have a right to do. And our township planning commission, our township board, our planner, they aren't looking for ways to grant a development. It's not like we have a dog in the fight. Rather, we take a proposed development and we look at it in accordance with what our zoning ordinance provides and what our rights are that the state has given us. We're not supposed to say, you know what, we don't want this development, so we're going to find a way to not allow it. If we were to do that, that's when we get hit with the lawsuits, and that's when we get hit with damages. And a lot of communities have been hit with large sums of damages because they've been unreasonable. So when the township get a proposed development, we're neutral. We have to make sure that that development complies with our zoning, and the experts say that they can take care of their groundwater, stormwater, and all that kind of stuff. And if it complies and it's reasonable, we have to grant it. Otherwise, we're subjecting ourselves to litigation. And so we have to be neutral. But you're right. I mean, there's lawyers out there that are looking to make loopholes. They don't exist now. They make them by convincing a judge that they're there. We fight those proposed loopholes. And you know what? When a third party gets to make the decision, you never know what they're going to do. And that's the problem with getting sued. Because if a township action to deny is deemed unreasonable, we lose control. And you now have a judge deciding whether or not that development is going to go in, and he may decide that I don't even like some of the regulations that they impose, so I'm going to make it a little bit looser. And that's one of the things that the township has to take into consideration. And that's why we have to remain neutral. We just take a look at the plan in a neutral way. Does it comply? Doesn't it?
I have just a very quick question. Sure. To his comment. You said what they deem reasonable. Well, who deems what's reasonable?
Well, if it goes to litigation, it's a
No,
judge.
I'm not talking about if it goes to litigation. As the board is looking at what's reasonable, how do they determine what is reasonable? What standards do they go by?
Well, just so you know, in our zoning ordinance, in our zoning classifications, we have what they call, for example, minimum lot sizes. We have no choice. It's a minimum lot size. Now, there are ways to adjust that a little bit through cluster zoning or something like cluster development or something like that. But when you do things like that, you're not supposed to have more lots in a development than you otherwise would if you had the minimum lot sizes. Rather, what you get is you get more open space. You get the same number of units, you get more open space. So our hands are tied on a lot of things. But for example, you ask me what's reasonable. If there's an issue of stormwater and the development has a proposed stormwater retention area, our experts take a look at that development, that proposed development, and they take a look at the plans for the stormwater retention. And they make a determination whether or not what they have designed is reasonable in light of the topography of the land, the amount of precipitation that we expect over a 10-year period or 20, whatever it is. And they make that determination, and they make the recommendations to the Township Planning Commission or the board or whatever. And so we get a lot of input from these experts. They're taking a look at it as whether it's reasonable or not. And the township then, when the Planning Commission looks at it, they can say, yeah, based on the information, we find that the Planning Commission's recommendation is appropriate.
Thank you, Chuck. Hopefully that helps clear some things up. I know there was a lot of confusion in the past, so. All right, so with that being said, thanks again. Thanks for everybody for your questions. We're going to call the meeting to order. Please rise and join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you very much. You all may be seated. Madam Clerk, may I have the roll call vote, please?
David Walker.
Here.
Zach Tucker.
Here.
Mike Cunningham.
Here.
Kurt Schultz.
Here.
Jennifer Eden. Here. Herman Ferguson.
Here.
I think we have one addition to the agenda. It's the township snow removal contract. So that will be item number 2 under new business, snow removal contract.
So moved.
Support.
Been motioned and supported to approve the agenda as amended. All in favor signify by saying aye.
Aye.
Aye. Those opposed, that motion carries. Next is approval of the consent agenda, the regular board meeting minutes from December 7th, 2021. Excuse me. The treasurer's report from November 30th, 2021. Clerk's warrants and bills, December 15th, 2021.
So moved.
Support.
It's been motioned and supported to approve the consent agenda as presented. All in favor signify by saying aye.
Aye.
Aye. Those opposed, motion carries. Next, communications. Item number 1 is the Planning Commission meeting synopsis from December 14th, 2021. Item number 2 is the fire service run December 15th, 2021.
So moved. Support.
It's been motioned and supported to receive and place communications 1 and 2 on file. All in favor signify by saying aye. Aye. Those opposed, motion carries. Public remarks. This is the first opportunity for public remarks. This is pertaining to anything that we have on the agenda. You are given 3 minutes to make any public remarks. If anybody has any public remarks regarding anything on the agenda, this is the time to do that.
Sure. This is for tonight's agenda, correct?
Correct.
For Lake Urban.
Sure.
Okay. Hi, my name is Jeff Cooper. Live up here on Running Lake Road. I live right next to the property that's proposed development for this. One of the concerns, I've been to, I'll say the majority of them, not all of them, but the majority of the planning commission meetings. One of the concerns about this is the traffic. And that a PUD has to be off from a primary county-owned road. And it seemed like the commission was a little, with Carlisle Workmen, the wording in our ordinance says, shall be from a primary county-owned road and can be accessed. Well, they're kind of rubbing around the word can, whether we can use it. And I know for a fact that Running Lake Road is not a primary road. It is a secondary, locally owned road. So it's not a county owned road. And we're proposing putting in phase 1, I believe it's 46 houses off from a secondary locally owned road. But that's not what the PUD states. Or that's not what the ordinance. So there's a little confusion with that. So I want the board to consider that that's not a primary road, according to the Livingston County Road Commission, people that I've talked to there, it's not a primary road. So development going in of that size off of that road, in my opinion, is kind of dangerous because of the traffic that's going to be generated by that. I've looked at the traffic study from the county. 1,500 cars go up and down that road every day. And now we're going to add another 80 to 100 cars coming in and out on that curve. It's a very big concern of mine. My other concern is the environmental impacts that that's gonna have. I'm sure that's all gonna come up later on. I know there's gonna be lots of meetings about this. There are endangered species back there that we know of. You know, the water and the dams, that all runs towards Runyon Lake, that's a concern, that was brought up. So, that's just kind of what I've got for now. I did have a question as to who is the engineering company that did the road study that's in the packet? Because I can't find them.
Road study? Or the
There was the traffic study.
CNA?
Who is CNA and where are they from? Because I have not been able to find them, because I had some questions.
I think they were from Grand Ledge, I looked them up.
When I went to go to their website, there was no website. And when I found a LinkedIn thing, it said 2 employees. Okay, who do I contact? That's, because I have questions about the traffic study.
That's not uncommon. When we had the economic downturn, there were a lot of engineers that worked for companies, and a lot of engineering firms went out of business. There's a lot of independent 1, 2, 3-man engineer shows, just certified engineers.
Sure.
They're PEs,
Yeah.
they're licensed. A lot of them are working out at home. I know 3 or 4 of them personally that you know, I used to sell stormwater, so I'm pretty versed in stormwater, so we're gonna do real good on that review. That are 1, 2-man, 3-man shows, and,
Yeah.
or woman,
Sure.
yeah.
I was just curious, because like I said, I couldn't find any contact information.
Yeah, well,
And
I'm
when I-
sure- I'm
When I
sure-
talked to Ross,
I'm sure
it wasn't the emails that he got.
Right.
So,
Well, regardless of who did it, I'm sure it's gonna be scrutinized by the road commission, so.
all right, thank you.
Yep, thank you. Yes, Scott.
All right, I know it's preliminary, this is early stages, but I see a lot of wetland on these lots. And the stuff we got, information we got back on the road study was a short term, and it was during COVID. We all know during COVID shut down, there was no traffic here. So that's not a reliable study. I did a 10-year study back when Andrew was, and it was being the state police officer did the 10-year study, said it was remarkable about the amount of accidents on White Lake Road. That was state police. There's a lot of accidents on this road.
Yeah, I
He
can
did a lot of blind drives and curves and stuff. But I got another proposal for you guys. You know, I hear the gentleman every meeting throwing all this stuff out, what he wants to do, what he's gonna give us to create open spaces, the wetlands, he wants to make it a park. Hey, there's some property over there on the other side of 23. It's a great big piece of farmland, it stretches all the way to Fenton. It's all flat. Sewers are going, the roads are going a lot easier. You can get him as a partner. The planning commission said, they'll even let you buy used property off-site for open land. Donate all that property over there on Urban Lake to open land, because most of it's wetland anyway. And I'm sure this township will let you do anything you want over there, because I don't think the people would care. Because you got a primary road running down the expressway, you could put an inlet and outlet on the primary road, and you wouldn't affect anybody in this area. It's just too congested here. That's all they're saying. It's not that, I don't think it's not that we don't want the development. I live on Sullivan Lake. We paved our road. The engineer came down, put the drain pond in over there at McMillan Circle, and you want to see where the drain comes out through my yard? You get 4 or 5 inches of rain, I got a raging river comes through. And the only reason it's cleaned out is because I cleaned it out when I built my house. The road commission didn't. It was just all stumps that was coming across the middle of my yard. So I don't trust any engineer. I'm sorry, because they screw up too. And our waters anymore, we're just getting more and more rain. So you can't go by these studies that are 10 years old. It's changed, everything's changed. So, but I think there's a lot of, I mean, it was nice you brought it in, but I mean, we gotta be, I don't care what these studies are. We live it. We live it. I mean, last month, I mean, how many accidents on White Lake Road? You don't live it. I mean, it's not a straight, flat road. And it's just, I mean, Down by where I live, we did make the road wider. We paid for the road to be blacktop. And we can actually walk down the side a little bit safer. You can't do that down here. You can't do that down here on White Lake Road. It's dangerous. And that area down there's already had tons of accidents. And he's right. It's just the way, it's just that bad corner. And like I said, I think you're gonna do that development. We'll make partners with the guy across the street and use that for openly. I'm sure they'll work something out with it. I don't like that area. I think 80-something homes. I looked at that map. Most of those lots are wetland. Look at the map. The lines go right across, it's wetland. I mean, and I know on my lake, those people come down there and they're trying to eat all this stuff into the, and they're just gonna keep eating back. Who's gonna protect it? I know we can put it in a conservatory. I've seen that happen before. But like I said, that goes through a lot of lakes, that waterway. Anymore with all the stuff that's going on in this country and the world, we gotta start protecting those waterways. So guys, what?
Thank you. Any other more remarks? Seeing none, we'll move on.
Any other?
Oh, do we have any online? I'm sorry.
I don't see anyone with hands raised, no.
Thank you. Okay, moving on, we have unfinished business, we have none, so we're gonna move to new business. The first one is Lake Urban Crossing PUD preliminary site plan. Kurt, did you wanna take that?
Sure, I can, I'll try to go over this real quick. First thing I want to explain to people is the applicant is requesting preliminary approval at this time. The purpose of preliminary approval is to determine if the project is generally consistent with our zoning ordinances. Preliminary approval grants the applicant the ability to submit an application for a final site plan approval. It does not create any vested rights in final approval. So what the Planning Commission was tasked with doing is the applicant submitted a request for a planned unit development for the northeast corner of Runyon Lake Road and White Lake Road. There's roughly 158 acres in that area, of which there is a lot of wetlands and I guess streams and other things, but there is some buildable property on there. We had Carlisle Wortman, who is our planner, thoroughly examine all the information. A PUD, and I'll just do a brief explanation of a PUD for people. The applicant is requesting a PUD, and that's a planned unit development, which allows for approximately a 15%, up to a 15% increase in the number of lots that you would normally have. When the applicant presented his information as a request for a PUD, he had to supply what's called a parallel plan. And that parallel plan stated how many lots could be built upon using the normal lot size, setbacks, and appropriate placement of the lots within the development. And at that point in time, there were, I believe, 77 in what's called the parallel plan. The PUD would allow up to a 15% increase in the number of the lots, and if certain criteria were met. And those criteria are things like open space, stormwater management, parks, walkways, access to lakes, and so forth. So what the applicant was requesting be done is that he asked for the PUD to allow more lots. That would result in approximately 11 more lots. So from the 77 lots that were originally buildable in that area, it would now move to 88, which would be done in 2 phases. A west phase, which comes off of Runyon Lake Road, and an east phase, which would come off of I'm going to read a couple of things off of Carlisle Workman's report here. The proposed planned unit development appears to preserve more natural features than a conventional development, i.e. parallel plan, provide more pedestrian circulation, and would locate more dwellings in an area served by public services, which is the sanitary sewers. The proposed planned unit development would result in 11 more lots that appear likely reasonable as part of an otherwise permitted development. It does not appear likely that the additional 11 single-family houses would result in significant increase in demand for public services or facilities. And the last one here, it appears that the proposed planned unit development is more likely to protect and preserve natural features on the site than a conventional development, parallel plan. A significant portion of wetlands will be located within the common open space instead of within individual lots. So, as a result, the Planning Commission provided conditional approval for a preliminary site plan. And that conditional approval and continued to provide an additional, well, actually 9 items that the applicant would have to continue to provide before any type of final approval could be rendered. And I just briefly, he had to, special land approval use can only be effective upon approval of a final planned unit development and final site plan. Originally in it, we had asked for a cul-de-sac to have an area in the center that would be open space. Fire marshal doesn't want that. He wants to be able to get his trucks around the cul-de-sac. So that was one condition that we had to eliminate. Basically, he has to go through the whole process of getting permits, Drain Commission, Eagle. I asked him for sites in the ground to make sure that everything is clean. So for the approval, that's what was gone over. And basically, his request was approved that we okay the preliminary site plan because it meets the requirements of our ordinance. So I would move that the board would approve the preliminary site plan for Lake Urban Development.
Are we gonna have further discussion?
Yes.
Okay, because I have some questions.
Well, the chair would like to make a motion, and once it's supported, you can have discussion.
Okay.
I have a motion on the table. Do I have support?
I support it.
Okay, so it's been motioned and seconded to approve the Urban Lake Crossing PUD preliminary site plan. Further discussion?
Yes,
Well, I have a question, Kurt, on those conditions. The first 11 look like those should have been satisfied already. Those look like they were planning commission conditions.
That's correct.
So why are they still not satisfied at this point?
Well, most of them have been, and if I go through these, a lot of the things like normally you wouldn't get a traffic impact study into a final site plan, for example. And that was done on a preliminary basis because there were a number of questions regarding the traffic flow issues on both Runyon Lake Road and White Lake Road. We already determined, and in fact, the final preliminary site plan that was provided met the conditions that were listed here for the criteria of the preliminary site plan, special land use, and the fact that we would not require non-contiguous open space the open space requirement was 3.35 acres less on the upland part of the, there's an open space calculation that's based on, there's so much open space that can be used for water, so much for wetlands, and so much for upland. He's actually preserving more space, but doesn't have quite enough upland area to cover. So the Planning Commission waived the requirement for 3.35 acres more of upland area that would have to be in open space.
So, I know we don't have minutes for these meetings.
Right.
However, I did go back and look at the meeting from November 30th, and I did look at your motion, and it was confusing as heck.
Yes.
Because honestly, I don't really know what you guys approved, because at first it looked like it was 1 through 11 less 3, and then there was another motion for 1 through 10 less 4. I don't know what actually got approved. There was a lot of confusion there, so I don't, if these conditions 1 through 11 had already been met, then why did the motion say 1 through 11 less number 3? I guess I'm confused. If all those conditions were met, then why was your motion to?
Well, there was,
Before you answer that,
sure.
nothing has been approved.
No,
The
but,
planning commission doesn't have authority to approve it in their recommendation.
There,
or-
it's a recommendation.
Yeah, so you made a recommendation to approve. I wanted to clarify that because everyone keeps saying it's been
Gotcha.
approved, it's been approved. It has not been approved. The only people that can approve it is the township board. It's a recommendation for approval. I just wanted to clarify that, not throwing anybody under the bus, just clarifying it.
and I misspoke.
We know what you mean, but they might not know what you mean, so I just wanted to clarify that. Go ahead, Kurt.
Okay, those first 11 are items that a lot has to do with the detail on the scale of the site plan. That was asked to be changed to 1 to 150. So there are a couple of items we haven't seen the final on yet. But the scale was something that, and a lot of the other issues on here, to waive part of the requirement for the location of structures within 500 feet. There are basically only one structure, I think, within 500 feet of the development. The traffic piece was completed. Statement of use is necessary for preliminary review, and that was provided. Again, a number of these issues on the first 11 there were items that we had given the applicant to do prior to him coming to the meeting, that the recommendation was made.
So where is the information that those items have been completed?
Yeah, in the past, we've gotten a letter from the planning commission saying what the conditions were and whether or not they've been satisfied. I did not see that.
I thought that Rich put one together.
I did not see
So,
it.
I mean, there's a summary in the beginning, but frankly, I was looking at it, and I had similar concerns even with that, because it was a little unclear as to which conditions were being waived, and it said some of the items 1 through 11 in these preliminary matters had been addressed, but, which leads me to believe that some of them had not. And I'm not certain, I'm not trying to pile on Kurt, but
No, that's okay.
I was concerned about that as well.
Because I did not see the recommendation sheet here before I got the packet. Let's put it
Yeah,
that
right,
way.
the one that I was looking
So
at.
my question to the board is, how can the planning commission give this to us as a recommendation when those items we do not have proof that they were satisfied?
Well, frankly, they can do whatever they want to, they'll send it back. They can do whatever they want.
I'd be concerned because the board's not very well situated to make sure that these requirements are met. That would be my concern.
Well, the other thing we could do too is amend the motion for conditional approval to include the completing these prior to full site plan review and approval.
I'm not approved, I'm not.
It seems like it'd be better to send it back to the planning commission, ask
think
them
we have
to
all the
verify
information.
everything's been completed, and then send us a summary that everything's been completed.
May I say something, Emma?
Wilson, I'm sorry, go ahead.
May I say something?
Sure.
Most of these items on that list were things when the planner, I mean, after coming for like 12 meetings here, and all the things required that provided, these things are required for the final. So most of the things in the preliminary site plan approval we've done, and as you mentioned, Mike, we did even the traffic study when it was not required for the preliminary site approval. So all these things have to be met before the final approval is given, because these are things that are gonna go to DEQ and Eagle and the road commission and the traffic study that we've done, and the fire chief when he gave us the okay, says the only thing we're gonna have that cul-de-sac. So all these requirements are required for the final approval. Has nothing to do with the preliminary site plan approval. But the planner, what he's done, did his job, is putting a packet with everything is needed for the preliminary and the final approval. So what are the things that we need to start working on?
Yes.
So the conditions that haven't been approved per se,
Chef, would you mind looking at this and,
The conditions we're talking about are the ones that the planning commission are supposed to have done before it comes to the board. There's also a conditionary that has to be done before it's approved.
and I want our council to look at these and tell us if these terms and conditions, it's okay for us to go ahead and move forward with conditional site plan, or do we need to send this back to the planning
Some on the
commission?
page prior to and bottom.
What is it that I'm looking at?
You're-
That's Carlisle Wharton's analysis that they provided the planning commission for us to discuss with the applicant in regards to what changes needed to be made.
It starts on the prior page.
Okay, yeah, we're on 3 here. I think before I can take a look at it, the first question is what did the planning commission recommend approval of? Is it things, saying these things have been satisfied or not? I can take a look at these and give you some sort of idea whether or not the township board can accept the recommendation and decide whether to approve this preliminary plan or not, maybe with conditions on it, if that's what you're looking for, whether or not we can do that,
Right.
or whether we should send it back. Have them. So let me take a quick look at it.
I think we don't know what the conditions are.
That's my concern, is that we don't.
And what has been done, what hasn't.
I mean, frankly, the summary letter from Rich says removal of item number 3. This is moving on to the conditions for final approval. But we were talking about number 4, not number 3. I'm just worried about all the lack of clarity here.
Really,
Well, I'm trying to do this.
the conditions are those 1 through 10 at the end.
Mhm.
But at the same time, usually there's a letter, and what we're hearing is most, but nobody's defined what most means. So is most 3, is most 5, is most 7, it seems unclear to me as to what you're actually asking for approval on without telling me what most means, okay?
My first observation is that on page 26, the last section says the list below includes items that require planning commission determination. And I read that as the planning commission has to make a determination as part of the recommendation to the board. That's from what our planner is saying. Am I understanding this correctly?
Yes.
There's also a comment in the parentheses, Chuck, that
Although the planning commission has not discussed some of these determinations previously, it is best practice to confirm them at time of review. And I'm assuming that was the review that the planning commission has had.
Yes.
And so, my reading of this is that these things should have been considered with the planning commission. And the planning commission should have made a recommendation as to this preliminary plan and addressed these issues. And so, if the recommendation doesn't clearly say what is being recommended, then the township board is kind of left in the dark as to what we are reviewing as far as a recommendation.
And
The question,
to be clear, Chuck, what we're hearing is most, but we don't know what most means because is most, there's nothing clear in documents that we've been providing that tell us that most of these have been met.
yes,
So the point is it needs to be sent back so that we have all answers to all 11.
I think that is one of the two options.
Okay.
The
What's
other
the
option
second
would be the township board can make some sort of determination, up or down, or with conditions. But the problem is that we don't know which of these things have been, are part of the recommendation for approval.
So the answer is send it back. I like two, so the answer is send it back.
So we will have to withdraw your motion.
As I say, you've got a motion, so you can either withdraw it or you can vote it down. You've got two choices, but you have to do something with the motion.
I'd make a motion to send it back to the planning commission.
You already have a motion in front
Oh,
of
excuse
you.
me.
He just-
So your choices are to rescind the mover of the first motion.
He just did.
Oh, did he?
He
Okay,
did.
then we're good.
Yeah.
Yep.
Okay.
I'd move to send it back to the planning commission so that they can address the outstanding items 1 through 11 and really probably clarify as to the final approval items 1 through 10, you know, which ones apply and which ones don't.
What about that, excuse me, that second list?
The second list,
The
Oh, I'm
second,
sorry,
yeah,
I'm sorry.
He's talking
There's
about
1
the
through 1 through 11 and 1 through 10.
Right,
Okay,
yeah.
Okay.
support.
Been motioned and supported to send back to the planning commission for clarification on the second list on which items have been completed. Any further discussion?
I would just add, I also included in my motion the first list as well.
Okay.
So I'll try to make sure that I'm clear since we lack clarity right now. 'Cause the planning commission, if I'm hearing what Chuck is saying correctly, also needs to determine whether that.
Let's
list
just
of
start over,
criteria-
withdraw your
Fair
motion. Withdraw your,
I'll withdraw my motion.
now start over.
Okay, so I would move to send this matter back to the planning commission so that they can determine as to whether items 1 through 10 in the planner's report have been satisfied. And also so that they can clarify which conditions in excuse me, I'm gonna withdraw that again and I'm gonna start over.
Can
You're
I,
not
can I,
voting yet.
can I make a suggestion,
Yeah.
the township board?
Please do.
We haven't had a thorough discussion by the board on what has been sent to you. We've only had the first part of this, and right away we came up upon an issue. We don't know what other issues there may be.
Sure.
So don't limit yourself as to what you're sending it back. You may put in a motion, for example, we need clarification on these items, and also say that the planning commission should make a thorough and clearly articulate recommendation to the township board, so we know exactly what it is recommending to us. So don't limit it to just those two list of items, because we haven't discussed any of the other things.
Good idea, let's discuss. Anybody have any?
Does anybody have anything else that is of concern?
I have concern about the open space.
Okay, you care to share what it is?
Well, it looks like they were trying to do a calculation using the submerged land, the state regulated wetland, and the 15.44 acres of upland, and it looks like they're 3.35 acres short of the required open space, which Kurt, I think, alluded to, that they were giving them a waiver
Yes.
for that. I don't understand why a waiver, I guess. We didn't give a waiver to anybody else because they didn't meet the open space requirements. So can you elaborate why we would do that in this case?
Well, okay. The request for a waiver, which the planning commission, according to the planner, has the authority to grant a waiver with board approval, would be to allow the fact that they were actually going to have more open space than necessary. However, they can only use a certain percentage of upland, of wetland, and submerged water, or submerged land, I guess you would call it, for the calculation. If we didn't provide a waiver for the 3.35 acres, I'm not sure that the process would allow the applicant to provide 88 lots or the 15% maximum. He would have to, I believe, lose 2 more lots out of that, I think is what the calculation was.
But ultimately, he's giving us more open space as a total than is required,
Yes,
and getting this as a reconciliation.
right.
But is he using the wetlands as open space? Is that,
Yeah, and it's admissible.
It's just a percentage of it.
Can I step the podium just to get that?
Sure,
I mean, I've never
absolutely.
met the board before. I'm the applicant. I would like to tell you about something about the project, about myself.
Sure, absolutely.
My name is Wilson LaHood. I reside in Benton, used to live in the hills of Tyrone. I did purchase the property from the township, was a tax sale like for 74 acres, with 74 RUs. And there was some limitations why this property cannot be developed as like any light property. The biggest concern is the amount of water on premises. That was the biggest concern, that you cannot build almost like a high density. But the second main thing was, from the entrance of Runyon Lake, that property only had 55 feet. So no one could develop that in the subdivision, even if they wanted to, because of that small limitations, because you gotta have 66 feet for right of way to go inside the sub. About a couple of years ago, I was able to get with the owner of the property on the corner, and he was in an uncompliant lot. His house was, according to rules and regulations. So what we did, I took from him 11 feet to give me the 66, and in return, I gave him more of a triangle, so now he's got almost a complete square to become compliant with your rules and regulations. So when I purchased this property, it's almost coming up to 5 years from you, the township. My plan was to develop it. And some of the things that I had challenges with, I knew up front that I got challenges, and this is why the previous owner had challenges, could not develop that land. So the first hurdle was to buy these 11 feet on Runyon Lake. So I bought 74 acres from the township, then I bought 13 acres on White Lake to connect that, even though it doesn't connect, by water, not by land, it might probably by wetland. And then I purchased, above that, before you get to Heartland, the 80 acres. So as an investor, this is what I had to put in, with some thoughts, ideas, and stuff like that, and to get to develop it. We started talking to the township over like probably 2 or 3 years ago. At one time, I wanted to have a PUD, do some kind of commercial. Some of the people in the township had indicated they might not like some commercial stuff, or even kind of like a multi-family or whatnot in single family. So we scratched that. So after the planner was hired by the township, we probably attended about 11, 12 meetings. Tedious meetings, honestly. I mean, it's great working with everyone, but a lot of times they would change the faces, that sometimes we go over one point, now we have another point to go through the whole thing. So all along, we've been extremely open and compliant with the township had asked for, and I would never ask for something more or something that doesn't make sense. At the end of the day, I want to have some, beautiful development. I'm a Fentonite. I like the area, again, I used to live in Tyrone Township in previous marriage, but, you know, when you mention about the open space, we're giving back 50 acres more than the required for an open space. And like I ask anyone, if you want an open space, would you like to have it in a farmland, open field, or something beautiful to preserve the nature of that property, in wetlands and trees and streams and stuff like that? So that's the only reason we're asking for the waiver of 3.5, and I think you were asking, you know, about it. The thing is, when you do, even in the wetland, as far as open space, you have certain percentage that you can do. So, according to your ordinance, either if the planning commission have the right to vote to approve not having the extra 3.5 acres, if the property has challenges, and there's a lot of hardship in the things of the property itself. So this is the reason the planning board made a recommendation, because the second thing was, you know, it's again to the rules. I could buy another 3 acres somewhere else and dedicate that, you know, to complete that requirement. You know, and another thing too, you know, we started with this plan almost 122 lots. Came down to 111, now down to 88. So we're trying to do half an acre lot, something very nice and pleasant in that development. But it seems every time we get close, and I think I just, you know, gets pulled back. And I know nobody intentionally is doing that. But at one time, folks came in the public meeting from the Hills of Tyrone and really were upset a bit about, you know, the shedding of the water up there in the cul-de-sac that the plant owned. I don't have the plan back. And one point, at the end of that phase 1 roads, kind of bust the Hills of Tyrone. So we give up 3 lots. These are premium lots on the water. Again, just to appease everybody. But, you know, I just want to reach a point that I think I felt that we got to someplace. You know, it seems like, again, we're given, and as I mentioned in these notes, that are from 1 to 9, again, the planner he was forthcoming and proactive in providing what are the things that's needed to have a final approval. So when you present things to have a conditional preliminary approval, as we all know, this is just the first step. I still have to go to TEQ, we still have to do soil boring, you know, still have to do traffic count again, it was done. Because he was asking for items that's not required from preliminary site approval. I cannot spend money more until I have the preliminary site approval to satisfy everything that's needed. You know, when we did the study on this property, we did 2 wetland studies, and we didn't put anything that cannot be put on. You still have to do soil boring to see if you need pylons or not. But these are the things that we've done. So, you know, I don't want to, I mean, it's kind of upsetting a little bit that, you know, these conditions were put for the conditional site plan, the preliminary site plan approval. Going back then, again, it's been like about 12 meetings that I've been coming to. And with the parallel plan, we've done a lot of stuff. We're going to have some, you know, a lot of folks were saying, well, it's going to be dangerous and what, and I literally understand that. But one of the others, I was here one time, mentioned that, you know, once you have a subdivision there, it's not like only private to the people that live there. I think that's going to provide even more safe area for people that want to walk on White Lake, when we all know White Lake is kind of hilly and stuff like that. The second important thing to preserve the wetlands is we have sewer instead of having septic. That's we all know it could fail and it could damage further that thing. So from the looks of it, it's a challenging property, absolutely gorgeous property. I walk it and I hunt it and I know this property. But again, there was a lot of time and effort put into this to get something. And we're not asking for something beyond anybody's control or approval. Again, you know, that part of the open space, the 3.5, it says in your ordinance, the planning commission can approve waiving that in case you have challenging property. Maybe it's only my opinion, but I think it is a challenging property. So what we're getting today is getting beyond the first step, the preliminary, so we can do more, you know, that time consuming and meeting with Eagle and the DEQ and the road commission. So they still have a lot of stuff to do. So I don't know if anybody's got any questions for me, but I just wanted to mention, you know, what's been going on. I really appreciate everybody's time, but I just want to feel that we're moving a little bit forward instead of throwing back the planning commission and just going a couple more months. And again, we gave up on 2 or 3 lots, you know, just because people had said a concern, you know, that would satisfy it. But I don't want to have less lots in this development, hopefully. And I just, you know, want to feel that we're moving forward. So these conditions, again, there was for, most of them, I mean, I wish the planner was here, but the reason, he did this recommendation, because most of them are needed in the final site plan, not the preliminary site plan. Thank you.
Thank you, Wilson.
Thanks.
I have a parliamentary procedural question here. Our planning and zoning administrator is watching. He just texted me and he would like to chime in on those 11 conditions. Is it appropriate to put him on a speakerphone, have him come in on Zoom? Or can I not take his comments to the board regarding this?
I think you can put him on Zoom and he can give information.
Let's see if he can get on Zoom. He's having problems with his Zoom.
Just by regular phone so everybody can hear.
Yeah, I can put him on speaker.
Yeah, he's not part of the board, so he doesn't have to be here.
Okay.
I got one question while you're doing that. Let's say that this was approved to go, who was determined, like you got 88 lots. What if Eagle comes in and said, no, you gotta cut this down to 55? They're the ones that's gonna determine where the wetlands are, correct?
They're going to determine what's buildable and what's not buildable.
Yes, the state, I mean, we can grant approvals,
Right.
but unless they satisfy the state, it's not gonna be built.
Exactly.
So you said, Wilson, you already had 2 studies that were done on the wetlands?
Yeah, I mean, the whole property.
Who did the studies?
I honestly don't remember, but they're in the files. I mean, we provide everything,
Well, they might be completely different, what
Ross,
Eagle has
hold
to
on a
say.
second. Okay, Ross, you there?
I'm here.
Yeah, so what we have is, the board is a little confused. There was 11 conditions that were put on the applicant by the planning commission.
Yeah, based on the memo, correct?
Yes.
So the 11 conditions, and then there were, let me bring up the memo here, so I make sure that I'm speaking accurately, let me find it. My internet is very slow, so bear with me here.
Welcome to Tyrone Township.
Comes from a satellite dish.
He doesn't have broadband.
So there were 2 items in the memo. The first list were, I believe, 11 potential waivers that the planning commission could grant based on the standards in the PUD article for preliminary PUD approval. There was a second list of items that, if I recall correctly, was regarding conditions that the planning commission could place on, or they could place on final. And it's my understanding, based on the motion at that meeting, that they decided that, yes, we do want to incorporate most of these conditions, not all. I think they excluded 1 or 2 that had been submitted prior to a more updated review. But here, give me just a second here, let me find the packet.
Take your time. I want to make sure we get this right.
Yep. So while I'm looking for this, in summary, this is just preliminary, and it does state specifically in the ordinance that this does not in any way, shape, or form guarantee that they will get final approval. It just is the first step in the process. It's a two-step process before they could move forward to final. In between preliminary and final, they are required to get the agency approvals and or reviews, which are required from Livingston County, from the state of Michigan, any applicable federal agencies, basically everything in between. So this is a big picture plan, which if they meet the standards, if the planning commission determines that they can give waivers for certain items because the PUD is flexible, then they can move forward to at least go through the agency review portion of the application. They need to put together a complete final application for the ordinance standards before they can come back. But this is basically the planning commission looking at things like maximum density that they could potentially
So just so I'm sure, while I'm waiting for this to load, the specific question is the conditions placed on the application?
Also, the determinations, Ross, I don't know if you can hear me.
Also, the planning commission determinations, Ross, the list of the first
Okay.
11 items.
Okay, they determined all of those per the motion that's included in the recommendation letter that those have been waived. However, the items remaining, the 10 items in the under review, will be required prior to final.
So where is the information that all of those were approved or taken care of, or waived?
Well, if you watch the recording, they went through item by item, and the motion is summarized as those items were waived.
Okay, why wasn't it in our packet?
It is in the packet.
No, it's not.
Where would it be in the packet, Ross?
So if you read the recommendation letter, which I've got this bill spinning, I can almost get to the packet, but not quite. In the recommendation letter from Rich, we have the motion there. So let me know. I have that up. Kurt Schultz made a motion to recommend Township Board approvals of the Lake Urban Crossing preliminary PUD application conditional upon items 1, 2 through 10, excluding item 3 from the potential conditions section. Oh, and hold on, I lost it.
Here's
Ross,
what it says. It says Kurt Schultz made a motion to recommend Township Board approval of the Lake Urban Crossing preliminary PUD application, conditional upon items 1 through 10, excluding item 3 from the potential conditions sections of the Carlisle Workman Associates review letter dated 11/4/2021, and at the bottom of page number 27.
and,
That doesn't say anything about what we're questioning.
well, and it
Planning
also,
commission determinations.
sorry, it also references number 3, when I believe number 4 is the one that is supposed to be,
56.
right.
You're right.
Other items of note, that the applicant did provide traffic impact study for the years 2016 to 2020. Also agreed to move 4 lots to the border, as well as agreeing that they will put a cul-de-sac at the end of the Valencia as directed by the fire department.
I'm working with T3 trying to bring this up here.
Okay.
On their letter to the township, it's referring to the conditions of approval, not what we're asking. The planning commission determinations. It's not referencing that at all in that acceptance letter. Approval letter, excuse me.
Yeah, so I'm having a lot of trouble here trying to bring this up. Basically, those items, the initial section, which I believe was 1 through 11, were the items that were up for planning commission discussion during that final meeting when they made the recommendation. If you go through the recording of that meeting, they went through item by item and determined that they would waive or modify those specific items. The items 1 through 10, they, as far as I recall, were required prior to final. They would need to add those items. But for preliminary, the recommendation was unconditional, other than the items that were required prior to final. I watched the recording like 3 or 4 times after to get clarification from questions the applicants had, from questions that residents had, in order to answer them. And I apologize if it hasn't been recorded completely accurately, but everything is there in the video recording. As far as procedurally going through all of those items, waiving and or modifying, and then the conditions being required prior to final.
I don't know, I think the one thing that's kind of odd is all the conditions were put on prior.
So let me clarify here, all of those were recommendations or conditions from our planning consultant. They're not the conditions that the planning commission necessarily places on. Now, they did decide to go with those conditions, but as far as the consensus that I got afterwards and the recording and everything else, it was, those must be fulfilled prior to them coming back for a final application. And I really, really wish that I had these documents in front of me right now.
So do we.
What I would recommend at this point is, if you bring up the zoning ordinance, the PUD procedures, go through the preliminary requirements and the final requirements. Don't even need to go to the final requirements at this point. Basically, it says everything that the applicants need to provide in order to get preliminary, which it does state right in that section, I'm going off of memory here, that it doesn't guarantee final. It does not say that they are. I'm struggling.
The application is generally, here's the summary comments from our planner. The application is generally complete, but there is some information that has not been fully provided at this time. If the planning commission determines missing any information is not eligible for waivers or is necessary for its preliminary review, it should postpone the action and direct the applicant to provide the information. Missing information that the planning commission does not determine is necessary for its preliminary review could be added to the plan submitted for final approval.
Where are you reading off of? Right
That's
now?
summary and comments of the planner's review.
Okay, now that was not a review based on the absolute latest version of the application. That was the latest review that was
Gotcha.
available, that the planning commission used during the meeting where they made the recommendation. So that letter is not the planning commission's motion. The planning commission's motion is what is recorded in the video,
Correct.
which unfortunately, based on when it happened, and we don't have actual minutes for it, but we do have the actual recording of it. It breaks down absolutely everything that occurred. And that is available on the website, and that's available in multiple formats. You know, in an effort to try to make things go as quickly as possible and not hold anyone up any longer than they needed to, and well, the fact that we haven't had a chance to have another meeting to approve any such minutes, we don't have minutes available. So if you'd like, I can go through and I can transcribe everything. If it's necessary to table, I can transcribe, not just minutes. I can put everything down word for word in a document for review, if that's what's necessary. But I'm having a hard time trying to find any reference material because of my terrible internet connection.
Yeah, well, unfortunately, the review letter doesn't give us enough to say that those terms were waived, met, or whatever. And I think
So the planning commission review, or the planner review letter does not mention the motion at all. The motion was based off of that review letter.
right.
So that's not going to reflect the motion unless we were to require that the planner create a post-final meeting review, which I have never seen done. But it's something that we could try to request.
Yeah, our chairman didn't clarify enough in his letter for us to move forward, I don't think.
Okay.
So I think that's where our sticking point is, so.
Well, yeah, you're asking us to make a decision on most and a
Gotcha.
consensus. Most and a consensus isn't a vote.
Well, I'm
That's
trying to
just,
follow up as much as possible to try to
that's just
straighten
most
out
of the
exactly
consensus.
what
Oh, we're gonna straighten it out, no doubt about it. It's just, unfortunately, the applicant's gonna have to come back again, So, we'll get it squared away. But thank you very much for trying to make clarification of it, I appreciate it.
Get the minutes done.
You're welcome. I apologize
Right.
that I'm not able to help.
Yeah, thank you, Ross.
Get the minutes down, I'm tired of watching
Yeah.
videos about this. Get
I-
the damn minutes.
I agree with it. I
Get
think
minutes
meeting
done.
minutes for anything like this that we need to approve or not approve. we
Yeah,
need
watch the
meeting
video,
minutes,
but I don't wanna watch the
period.
video. I wanna see the minutes. I need to read it, so.
Well, it's hard to hear too sometimes.
Yeah, I watched the video and I wasn't sure what had been, yeah.
So,
And I'm not voting on something that is most in a consensus, so.
you want to take a whack at your motion again there, Zach?
So I would move to send this back to the planning commission for reconsideration and a new recommendation.
Clarification.
Clarification maybe is a better word, yes. For clarification and a new recommendation.
Okay.
Support.
The motion and supported to send this back to the planning commission for clarification and a new recommendation. Any further discussion? All in favor signify by saying aye.
Aye.
Aye. Those opposed, motion carries. We're gonna get it. Sorry. Next is item number 2, the snow removal contract. This is a 2-year contract. This is with the Shoemaker Group. They've been doing our snow removal. There is no price increase on it. You know, being a public agency, we have to make sure that we have a safe parking lot and walkway. They do a pretty good job.
Well, doing snow plowing, I look at this, Mike, and I think they're giving us a very good, I wouldn't do it this cheap. That's a really good price. I mean, for what they're doing, $75, I would probably charge at least $125 to do the lot. You're doing this, it doesn't matter, that's why they've been
That's why your name is
Yeah.
on it.
Yeah. It doesn't matter. I don't need business that bad, but I'm just saying with this, it's $75 for 2 to 4, 4 to 8, 113, and then what they're gonna do with the salting. I would say make a motion to approve this.
Support.
Been motion and supported to approve the 2-year contract for snow removal with Schumacher. Any further discussion? All in favor signify by saying aye. Aye. Those opposed? Motion carries. Next is miscellaneous business. We have none.
Is that where maybe I should answer, or should we put it in public comment?
Public remark. Perfect.
Gotcha, okay.
Public remark, we're gonna do public remarks, but we have a question that was asked of the board. So Marcy's gonna read the question and then answer it, and then whoever wants to make a comment can make a comment.
Okay, I got a question from a resident asking, do the township's monthly bills need to be approved each month before paying? And what is the process for this approval? And we have a bill payment and board approval policy that allows us to pay the bills, and then we submit the clerk's warrants and bills at the next board meeting for approval. And so I do have that resolution, it's 090103, if anybody wants a copy of it. And we also have a resolution each year when we approve our budget. So we have that resolution that also allows the township clerk to obligate the township in an amount up to $2,000 without prior approval of the board. I also have the authority to make capital expenditures up to $400 with authorization of the board at the next meeting. So, so I hope that answers that question, but if not, follow up with me and I'll get more information.
Thank you. Anyone else, public comment? Yes.
I just want to clarify that. The gentleman comes to the meeting, I know he wants to get this development going pretty bad. The reason for the sewers isn't because he wants to protect the wetlands, it's because we can't get drain fields in there. That's number one. It's, you know, the water table is just too high. I always thought there was 19 acres over there, 74 acres, boy, that should have been a nice park over there. But really sorry we sold that property. But the recommendations we had, like I said, the road study, I'm not satisfied with his people doing it. You can go to Lansing and get a better road study. And I think we need a 10-year road study for clarification through the state of Michigan. Up to the COVID, not during the COVID. I'd like to see that road study, because I know I've done a road study. And like I said, I don't know, in the drainage, in the water situation, just going back 10 years, it's kind of hard to justify 10 years, what we've seen the last couple of years. I mean, I live on a lake in the system we're talking about, I'm just upriver a little bit. And my dock, I got a floating dock at the end, because if I don't, water goes over when we get the rains. And then I get the washout coming off the roads. So, like I said, I think we need our own studies. I mean, I don't think we should, I know it's just preliminary, but I think we should really work hard for the citizens to get our own studies and match them by the time we do the final. So thanks, guys. Merry Christmas.
Merry Christmas. Anyone else?
Say Merry Christmas to everyone.
Merry Christmas.
I don't see anyone on Zoom.
Anyone on Zoom? You want to bring Oscar up here for a minute? Well,
He's heard
still-
that.
We're gonna miss him.
This is Oscar, everyone.
His last meeting, maybe.
And for those of you that are watching it on Zoom, Oscar is a therapy dog in training. He's going to go to the Brighton School District. We've been fostering him for a little bit of time. He has been to Oxford Junior High School twice. He's a very sweet, affectionate guy. He's also been to Canton schools and Brighton schools. And he was actually, he's been to Veteran Treatment Court in North Oakland County. And he was also, you can find his picture on WHMI when the Brighton schools took therapy dogs up. Oscar's picture's there. So if you go to WHMI and search for therapy dogs, Oxford High School, you'll be able to see his picture there. So, thank you very much for bringing Oscar in. We're going to miss him when he goes, but he's a very special guy, and he's going to do great things for a lot of people. So.
He's a magical puppy.
Hey, Kelly, do you get visitation?
No.
No.
I'll get news articles, I'm sure.
Yeah, we'll get news articles, and that's it. He'll go, but he's a special dog. And he comes into the office here, and everybody really loves him. The residents love him. Everybody's got to touch him because he's so cute. So, anybody else have any comments before we go? All right, since we have none, I'll entertain the motion to adjourn.
So moved.
Support.
It's been motioned and supported to adjourn the meeting. All in favor signify by saying aye. Aye. Those opposed, the motion carries.
Get a township. Well, hopefully, they were trying to do this specific, but I get his point, you know, you don't want to be specific.
I'll take the gavel.
Shout out.
It's like on fire under your skin. That's just awful.
Pardon?